Welcome back to You Can't Say That in Court, a podcast by Rise Women's Legal Center. I'm Vicky Law.
And I'm Stephanie Melnick. We are your hosts as we continue this conversation about survivors of violence navigating the BC family law system. We recognize that the legal system we have in BC is colonial and causes harm to families, which disproportionately impacts Indigenous people.
By speaking openly about these harms, we hope to raise awareness about the challenges survivors face as they navigate the colonial family law system. Our podcast is an attempt to collectively identify the barriers and advocate for positive changes to be made. Thank you for joining. Our podcast series will discuss difficult topics such as gender-based violence and intimate partner violence. This includes physical, sexual, emotional, psychological, and financial abuse. Please be aware that this is a thread that is woven throughout all the episodes, and we hope you will take care of yourselves however you need. Hi, everyone. Welcome back to You Can't Say That in Court, episode 4. And we are continuing with our discussion about the barriers for survivors in leaving abusive relationships. And today we're going to take a look at some of the possible legal protections that are available through our legal system, both the criminal and the family, and try to explore about why they might not be working as well as we had hoped. So first off, we just want to spend a little bit of time talking about the criminal protection orders. These are kind of a precursor to the family law protection orders. So Stephanie and I just want to spend a bit of time on explaining what they are and why it might not be great for survivors to get them.
Yeah, and it picks up where we left off in the last episode when we were talking about how the criminal justice system responds to incidents of violence. Having some automatic protections that go in place, like specifically conditions that are against the accused, the person who is deemed to have caused harm, normally gets some kind of conditions placed on them at various stages where they may not be allowed to go to a certain location for fear of them causing more harm, or they might just have a few of their freedoms hemmed in a little bit until everything can be sorted out in a court process. And really, those different conditions or interventions can happen at a number of different stages. They're meant to be customizable. When you read some of the legislation or the guiding documents, the idea is that certain restrictions or protective measures will be used based on the circumstances. And you would think that in those cases, it would be the survivor who was giving some input to say, here's what would be helpful for me at this point. When we're talking about family violence, we want to make sure that the survivor is getting what they need. But there aren't often opportunities for them to feed that into the considerations. We did want to mention also that the criminal side of things is different than the family law side, mostly in structure because there's a Crown prosecutor who's a government lawyer who is going to be the one moving the matter forward in the courts. And that just creates a much different dynamic than on the family law side when each side is representing themselves or has a lawyer representing them. So it just becomes a little more complicated trying to find the right fit for protection from family violence on the criminal side. Yeah, I think we
I
wanted
was
to, yeah.
wondering if maybe we can go through what those protection orders are, because I'm just like realizing a lot of folks may not know what protection orders are.
Right.
So, like the
Yeah, yeah.
terms of protection
Sure.
orders. So, Stephanie, you mentioned the no-go term. So, it usually
Yeah.
um, says like the court orders that person A can't go to person's B's house or
Hmm.
their place of work,
Right.
or school if they're
Hmm.
attending school. Another condition that we often see is that, person A can't contact person B at all,
Hmm. Right.
whether it's like by phone or in person, text messaging, email, all forms of communication are not allowed. There's
Right.
also like firearm restrictions,
Yeah. Yeah.
so these three are appear both in criminal and family law protection orders.
Right.
Yeah.
Yeah, and they can go in place kind of at the time of someone being arrested. So, in that
Hmm.
heightened moment of crisis where the police are called, then the police can put those conditions in place. And they often do automatically in the case of family violence. And there's a little less nuance at that phase because an investigation hasn't been done. Things aren't
Hmm.
moving through the court system yet. From what I've seen, once something is in the court's hands and conditions are being placed on a person who's caused harm, an accused or an offender, then the conditions often have exceptions. You know, there's no contact allowed except under these circumstances. So, for the purposes of arranging parenting, then you can,
Hmm.
you can communicate by email or those sorts of things, which is very similar to on the family side, right? But
Yeah.
on like in that initial crisis intervention moment when police are putting an undertaking or a promise to appear or something like that in place, then the conditions are pretty standard and not really super flexible. And that's where we're missing the survivor's input to make them more meaningful and to honestly do what they were meant to do, which is provide protection. Because if the conditions are unrealistic and a family still needs to function like a family unit to some degree,
Yeah.
then putting a wall up between two parents is not going to serve anyone's purpose, and it just sets everyone up for failure because breaches of those conditions can be kind of set in motion, and that's not the intention.
Yeah. So I just have a practice tip. If there are any
Yeah.
criminal practitioners listening,
Yes.
my my favorite exception is like for example, if person A cannot be in communication with person B, the
Hmm.
exception that I would prefer is an exception unless a family law order is in place to allow for
Oh, yeah.
communication. Because I
Yep.
don't because the problem with the criminal protection orders is, as you said, it's not in the hands of the survivor. And
Right.
so it's the Crown prosecutor who's leading and moving that process along. And and so when we have these weird criminal orders that bleed into family, but the criminal court is not the one that's deciding what's happening with the family. It's the family court that's deciding.
Right.
And sure, you can sometimes have the same judge who's like sitting on both matters, but that's just a
Hmm.
scheduling coincidence and a
Yes,
luck
it's
thing.
not
It's
designed. Yeah,
it's not
exactly.
designed that way. So my preference is always for the criminal conditions to say except in accordance with the family law order, and then the parties
Hmm.
can go to family court and figure out
Right.
what they need to do to make sure that they're abiding by the criminal law piece as well as needing everything that they need to figure out with the family law piece.
Right. And that actually is a great practice tip because it highlights one of the other problems with the criminal conditions or the protections that are automatically put in place, that they're often not responsive to the needs of families. And family law is
Hmm.
absolutely more specifically tasked with looking holistically at a family. There are some kind of myths or stereotypes baked into some of these protections on the criminal side. There's an assumption that if person A has harmed person B, then person B never wants to see person A again. Let's put up this wall of protection.
Yeah.
No contact, no go, that's assuming that but the person probably just wants to be safe while still interacting with their spouse over whether someone can take their kid to a doctor's appointment tomorrow. That kind of thing.
Yeah.
The yeah, the myths around how a survivor of violence is meant to behave or expected to behave definitely come into these types of protections. Yeah.
Hmm. Um, and there's also the flip side, which is that, the criminal side does trump the family law side. And
Right.
so when we
Yes.
have criminal protection orders that includes both the survivor, usually the mom, and the children, then that needs to be followed because there
Right.
was something that happened that required the justice actors to be like, hey, we should also include children in these like protective conditions.
Right.
Um, and that can be tricky too because then it prohibits the accused in the situation from navigating their family law
Right.
pieces. But I think what that situation needs to be figured out is like, let's figure out the criminal piece first, and then once
Yeah.
that's resolved, we'll deal with the family. But oftentimes families aren't their timelines don't work that way, right?
Right.
Like the two
Exactly.
are
Yeah.
interconnected,
Yeah.
and we do need a better communication and collaboration across the two systems for sure.
Yeah. Yeah. It's really hard when a criminal intervention and then priority matter kind of hijacks what might have been some momentum on the family side. Um,
Hmm.
yeah, it just kind of sets everything back too far. But generally speaking, criminal matters do take less time, again, because there is a government appointed prosecutor, a crown
Yes.
attorney who's moving things forward at a different timeline. But then the downside also is that a lot of the criminal protections that go into place don't stay in place long enough to even be effective because the assumption is that a criminal matter is going to wrap up fast enough. Stuff only, those protections are only there for a month or maybe 90 days. And
Yeah.
that's why also I really like your practice tip of coordinating that with a family law protection so that
Hmm.
the the nuance and the coverage is there. Yeah.
Yeah, especially because a survivor doesn't have control over the criminal piece. And so when there
Yeah.
isn't a criminal proceeding, then that means there aren't those conditions, those protective conditions are
Yeah.
removed when there is no criminal proceeding because
Right.
they're
Yeah.
tied to that.
Yes.
So that's kind of where some of the benefits of the family law protection orders can come in because the family law protection order replaced what was in the previous legislation of the Family Relations Act of the Restraining Orders. Um, and it just codified what survivors can do to obtain a family law protection order. It was more within the control of a survivor because it was an application based done by the person who felt unsafe.
Right.
Um, or by a family member who or anyone who could do it on behalf of a family member who was unsafe. So yes, in theory, it's supposed to be more responsive to the threats of a family member or perpetrator of abuse. But we all have also seen a lot of problems with this, and we've
Hmm.
highlighted these problems in another one of Haley's REMX reports on protection orders. And so we're just going to go through and identify some of these problems, which are also rooted in myths and stereotypes reasoning, unfortunately.
Yeah. Unfortunately, exactly.
Yeah, myths and stereotypes reasoning, unfortunately, is just pervasive in all gender-based violence. And so one of the problems that we saw that Haley saw in the report was that lawyers and judges not understanding what family violence looks like, placing a lot of the emphasis and the weight of evidence on physical abuse and
Hmm.
not taking into account any violence that's non-physical, so any emotional or psychological, financial abuse that we've talked about in previous episodes.
Right. Yeah. And also previously talking about standalone incidents versus
Hmm.
ongoing patterns, that police are going to respond to these specific incidents. That's kind of what the court system's looking for. And that's often a physical abuse situation. It's not often that someone will be calling the police at 2 a.m. because of a financial abuse
Yeah,
context. That context is an ongoing pattern, of course, of controlling behavior. And it just looks different from an evidence point of view once it gets into the
yeah.
courts.
Yeah, and for like the courts have recognized, but just to back up a bit, the courts have recognized emotional and financial abuse as forms of family violence.
Right. Yes.
But I don't know when we're looking at family law protection orders,
Hmm.
um, I don't know if it would go so far to for the courts to place a protection order on only financial abuse.
Right. Right.
Um,
Yeah, I would
it's
suggest probably not yet. Yeah, I
Yeah.
don't think we're there yet. Yeah.
There's definitely orders that are available in the legislation to prevent further financial abuse.
Right. Yes.
But a protection order is probably not one of them because it goes back to, the terms of the orders that we previously talked about, which was like not going to their place of work or residence, not communicating with
Mm-hmm.
them, except in certain circumstances. So I don't know how that would prevent financial abuse. Family law protection orders also have like a no stalking, like not following
Right.
order,
Yes.
which I have not seen in criminal protection conditions.
Right.
Um, and and it is odd because like the flip side argument I have heard is like, well, what if they just end up in the same place at the same time?
Right.
How can you prove that this person is quote unquote following the other?
Right.
Um,
Right.
But I think we've talked about this in our tech episode from last season, about tech safety and like
Yeah.
tech monitoring, right? So I think
Mm-hmm.
the
Yeah.
courts can be a bit more creative when we're looking at the no following, no stalking
Yeah.
condition.
Yeah. It's interesting being in a small town and observing criminal court in a small
Mm,
circuit court. I have heard more than once a judge say to an accused, if you go to the grocery store and she's already shopping, you put your basket down and you leave right away. That's what that looks like. They're just being really
mhm.
prescriptive, but recognizing that it's very hard to not accidentally cross paths, but putting a stop to that being an excuse, like something that a
Yeah,
perpetrator could hide behind and say, oh, well, we just happened to be shopping at the same
yeah,
time or at the mailbox at the same time, that kind of thing. And so that's that's a little bright spot in all of
yeah.
this as well.
It's good that the recognition is there for that.
Yeah.
The other problem that we have seen with family law protection orders is that children aren't included in these orders,
Right.
because courts are generally favoring continuing that the child has ongoing communication or ongoing time in real
Mm-hmm.
life with the abusive
Mm-hmm.
parent.
Right.
And sometimes we've tried to navigate that through, maybe like video call or phone call.
Right. Right.
But that's still not um the equivalent of in-person time. And
Mm-hmm.
so a lot of lawyers do strategize about, well, should we include the children in the protection order application or not?
Right.
Because it does take a different direction
Right.
if they're included. And I think that's just based on you know, the myth and stereotype reasoning as well here, right? Like an abusive parent can still be a good parent.
Mm-hmm. Yeah. I feel like this has, been a pendulum that swung back and forth
Hmm.
over many, many years and actually decades, the belief system. And it's very hard to find the right balance. I think it takes analysis of the specific situation, but trying to pull away those. Um, those stereotypes that, yeah, the belief that an abusive parent can still be a good parent, it goes against the like what's good for the children, and that
Yeah,
analysis of best interests of the children. So I think we're starting to hear some better positions on
yeah,
this, which is encouraging. Um,
yeah.
yeah, yeah.
I think it is definitely in the legislation, and we've got a few good court cases talking about it too, where
Mm-hmm.
indirect violence to the children or exposure to violence for the children is family violence, and it's
Yeah,
not in the
yeah,
child's best interest.
right. And
So
that's just,
it's
yeah, it's very logical. I mean,
yeah,
anyone who can imagine what that looks like, children witnessing or being in another room or something like that, like, of course, there's going to be a huge impact. That just,
mm-hmm,
yeah, makes a lot of sense.
mm-hmm, yeah.
Yeah.
The next problem that we have seen is the problem with what's called ex parte or without notice applications. So, in the legal system, usually a person gets served with documents, legal papers so that they are aware that there is a proceeding against them or that they're
Hmm.
involved in.
Yeah.
When we talk about without notice applications or ex parte applications, it means that someone is going to court with and seeking an order without letting the other party know about it. And this is
Hmm.
quite important in family law protection orders because uh, I think it's important. It's a part of safety planning, really, in my mind, because a
Right.
survivor needs to get protection um, without letting the other person know that
Yeah.
they're getting protection.
Right.
Um, we have heard a lot of people saying, I can't let the other person know that I'm going to court. I can't let the other person know that I'm leaving them or separating from
Hmm.
them. They would freak out.
Yeah.
There would
It
be an
just
explosion.
exactly. It escalates right away when legal action is
Yeah.
taken. Yeah.
Yeah. Or even separation. Like we've seen the
Right.
stats
Yeah.
that
Yeah.
separation is the most lethal. Um, like that's where the highest
Moment.
risk.
That's the
Yeah.
time of highest risk, exactly. And lots of literature highlighting how safety planning needs to be done by
Mm-hmm.
a survivor, and mobilizing to leave a relationship happens in secret. And here are the ways that that can be done
Yep.
so that they can exit the relationship without raising any flags for the abusive party, who is going to then potentially ramp up the violence in
Yep.
response to losing control of the person. So it's kind of reflected in, long-standing safety planning measures.
Yeah. And I think if the protection order is part of the safety plan and the safety plan needs to be done in secret, then there's
Yeah.
no way that the survivor can serve such an application on the abusive party.
Yeah.
And so oftentimes when we're doing these ex parte applications, we're explaining why it's unsafe
Hmm.
to let the other party know that there's a protection order application. Um, and unfortunately, it's not always successful.
Right. Yeah.
We have courts that are not comfortable with only hearing one side of the story to make a
Hmm.
decision. Um, it the legal system is based on the foundation that both sides are heard before they make a decision. So it
Right.
is um out of the ordinary, but I think when we look at protection orders, it is not ordinary. Like
Yeah,
it
exactly.
is a protective measure that unfortunately a lot of people need. So I don't want to equate ordinary with the number of people who need it. It's just
Sure. Right.
it's yes, it is extreme.
Hmm.
And a lot of people need that extreme resource to be safe.
Yes, exactly. And it's another example of where there's been enough recognition that there's a problem with the regular way of making an application to court,
Hmm.
making sure that both sides are aware and they're both going to be there to present their bit. There was recognition that that goes counter to the safety piece.
Hmm.
So having ex parte options means that the legislation is reflecting that recognition. Super great. Very encouraging. But then how does it work in practice? Because, like you said, in practice, the courts are used to and built on a foundation of hearing both sides and then making a decision. It's very, very hard to put it into practice. But I think, again, this is where that opportunity is to make the improvement, because the legislation was like that exception, or that option was included for a very good reason. And
Hmm.
so we need adaptations to allow it to move forward the way it was intended, which is without the
Yeah.
other side being there or aware.
Yeah, and I want to be clear, like ex parte applications are not exclusive to protection orders. There's other forms of
Right.
ex parte
Yes.
applications,
Yes.
and there is
Excellent
already
point.
law on ex parte applications. So we don't need to reinvent the wheel. We just need
Right.
to apply that to the protection order lens, to the protection
Yeah.
order regime. And when we can't just, you know, go in and expect that, like if we don't meet the elements of when an ex parte order is allowable, then
Hmm.
maybe the application is not suitable to be ex parte.
Right.
Um, but we don't need to start from scratch here. That's it's
Right.
already
Right.
there.
Yeah. Yeah. And if it does meet the threshold, then proceed.
Yes, we
Yeah.
we should be able to proceed if we meet the
Yeah.
threshold. So I think,
Hmm.
there's both sides there. Like, one, are the applications that are being brought before the court meeting the threshold? And B, if they do meet the threshold, are they being proceeded with, or are they wrongfully being
Right.
denied for whatever reason?
For whatever
Um,
reason. Yeah, exactly.
yeah. And I think that's where it leads to the next problem that we see is because courts are uncomfortable with these ex parte applications, they end up making these really short protection order, short length in duration. So like either a
Yeah.
week or 2 weeks, and asking the applicant, the survivor, to come back after 2 weeks after they've
Hmm.
served the other side so that the
Right.
court can hear both sides,
Hmm.
and decide whether a longer protection order is required. And
Right.
this is just a lot of resources going into something that is
Yeah.
supposed to be quick and preventative of future violence.
Right. And already acknowledged in legislation, the ex parte option is on purpose included for protection orders because there's recognition that there are certain situations where someone needs to get protection legally without notifying the other side. So
Hmm.
it's really counter to the whole point of that piece of the legislation to just put a protection order in place for a short period of time. There's no point. It doesn't provide
Yeah,
the protection that's required, or the safety
yeah.
that's needed. Yeah.
And what we have seen, so the legislation says in terms of duration, it's a if the order is silent on the duration, then it defaults to
Yeah.
1 year. But
Right.
what we've seen is like a lot of people taking that 1 year as the maximum amount of
Mm,
protection order duration. I've definitely seen orders where it's made indefinitely, like they will say in the order itself, like this protection order will not expire. But
right.
again, that's a very, very extreme circumstance where that
Yeah.
was made.
Yeah.
Usually it's 1 year or shorter. And when we
Right.
look at how long family law um, process takes and how long it takes a survivor to settle into their new life, um,
Hmm.
I think 1 year is too short. And it's
Yeah. It
actually
is too short.
a Dr. Stanton's recommendation to make it longer.
Right.
And I
Exactly.
think I think the BC government is considering that,
Hmm.
looking into that because 1 year isn't. I've never heard of someone resolving their family law matter in less than a year.
Right. And we do hear a lot from clients who have to go back again and again to extend a
Mm-hmm.
protection order or try to find a different type of protection, like on the criminal side, the peace bond option,
Yeah.
which strangely, one of the side effects of having the
Mm,
family law protection order put into legislation is that the criminal side of things says, oh, go over to the family law side and get yourself a family law protection order. That's what that's for. And somehow has, not with intention, made it harder to get a peace bond for situations of family violence, which
yeah.
yeah, was never meant to happen like that.
No, and the family law protection order legislation even says like someone can still apply for a family law protection order even if they have protective orders in the criminal system. Like
Yes,
both can
exactly.
exist at the
Both
same
can exist. Yeah.
time. So
Hmm.
it's incorrect for people to say, hey, you actually have this avenue in the family law order, so go do it. We're not going to help
Hmm.
you. And
Hmm.
people, I mean, usually this is what we hear a lot of the police officers are telling survivors,
Right.
right?
Yeah, that it's
Um,
not criminal, it's family. Go over
yeah,
to, a civil proceeding where, in fact, I think Haley's report highlights it really nicely that that is effectively downloading safety to a private realm. It
Yes.
kind of privatizes it by saying that, okay, the police are not necessarily going to help you in this situation. Some will, but some won't. And they see it
Hmm.
purely as a family matter. And then the survivor is only left with the option of hiring a lawyer and having to pay money to get that protection or
Yeah.
represent themselves or forego the safety that a
Yeah.
legal order can provide them. So that's again an entirely unintended consequence of creating this expanded protection order on the family law side of things. Like you said, they
Yeah.
should be complementary and they should be able to be coordinated and or overlapped to just do what they were meant to do and provide the legal protection. Yeah.
Yeah. So unfortunately, with this system, we've kind of monetized the
Yeah.
protection, right,
Right.
of the family law order,
Exactly.
where only people who can afford a family lawyer can get them, or if
Hmm.
people who are on legal aid, and their situation is so dire that they can't move forward with their family law matter except without, like, they need a protection order in order
They
to
need the
move forward.
protection order. Yeah.
Yeah. So then you've got the people in between who are either um paying a little bit to hire a lawyer for advice, or on legal aid contracts, and deciding, well, you know what, I'm not gonna waste my little resources on a family law
Right.
protection order because A, they're short, and all the problems that we've identified, and B, we haven't talked about it, but the enforceability part of protection orders,
Right. Yes.
which are low or non-existent, I think.
Yeah, it's the other big problematic area of family law protection orders is that they were on purpose meant to be and expected to be enforced as a criminal breach. And then Crown would prosecute a criminal matter. But that's, I wouldn't say rarely, but it's very common to hear that breaches of family law protection orders are not taken seriously by the criminal justice system, which is very sad to hear because, like we said in the last episode, if someone doesn't respect the law, or, and I didn't say this last time, but it kind of ties into this, that if they know they can get away with
Mm,
not complying with the order, then the order all of a sudden loses all of its meaning. If
yeah,
there is no enforcement, if there is no backing up of the rules that we've said are not allowed to be broken, then the rules lose all their meaning. Yeah.
yeah, yep. So I think we need a better system.
Yeah.
And we need
I
a better
think that's a
system.
great observation. Yeah.
At a minimum, by just working with each other, like working with each other and sharing information between the criminal system and the family law system,
Yeah.
collaborating with each other so that we put survivors and their children first, their
Hmm.
safety first, and
Yeah.
think about creatively what that means, because it's not a cookie cutter uh, approach. One size does
Hmm.
not fit all. Um, some survivors may want a protection order, and some may not want to go that way. They think that a protection order might exacerbate things, and that's totally fair.
Right.
So we can't always go in with this approach,
Right.
that the protection order will fix everything, but we have this mechanism. It should be making things better, and it is not. So
Yeah.
yeah.
Yeah, and collaboration is a good recommendation to end on. If there's and there's lots of research out there for lots of recommendations about coordinating efforts
Hmm.
across different areas of law and or different organizations in a community to make sure that everyone understands which dimension they can help with. I think that's definitely an area for improvement. And it's also where we don't need to necessarily change the individual systems as much. If there's more coordination, then they can just work better together and keep their own area of expertise. Criminal law and criminal justice can do what they do best while still talking to the family law side of
Hmm.
things. Then that coordination alone will fix a lot of the problems that we're seeing. And I'm
Yeah.
excited that we will be moving into recommendations and possible solutions in the next episode. I think that's a really good way to lead into it.
Yeah, I think next episode we'll be talking about recommendations that Rise has made about how our protection order system can improve and better serve the survivors and the children when they need them. So thank you again for tuning in, and we'll catch you next time.
Talk to you soon. Thanks.
Everything that we have said today is not legal advice. If you or someone you know needs legal advice, please consult with a lawyer.